But that one in particular, for him to post pictures of himself holding a firearm and having the audacity to put his tether in the picture that I ordered as one of his bond conditions is absolutely outrageous. And I can't think of a judge in this great state that would disagree.
Let's roll, nerds.
All right, so Mr. Walsh, you requested a motion hearing date on bond.
Yes, Your Honor. It's my understanding that Mr. Santana was out on a bond and made a very poor decision and posted pictures on social media with himself and some firearms, or at least replica firearms, if at the very least replica firearms. I'm not that my argument is not that they were real or fake, but that the pictures were posted and that it was a violation of his bond. However, I'd like to point out the fact that he didn't violate his tether. He didn't assault anybody. He didn't fail to appear. No curfews. Mr. Santana is 17 years old. And the law does provide for young people in a different way than they do for adults. They realize that they make stupid decisions. They have, and that's reflected in sentencing, and even in the way that the amount of time can be detained.
Can I ask this real quick? Because
Yes.
I want to make sure my memory serves me correct. Ms. Soap, is the allegation that Mr. Santana was the one who shot the firearm?
Correct, Your Honor.
Okay, so Mr. Wallace, I feel bad for you this morning. So, and I understand Mr. Santana is a minor. So I had in front of me an allegation that multiple individuals were at a location, something went south, and the allegation is that Mr. Santana, your client, shot a firearm into a human being's chest, and that person was in serious condition, at least at some point. I did the swearing on this. So someone shot in the chest, I believe at, when I say close range, under 20 feet is the allegation. And this was during, or the allegation is it was surrounding some sort of, rowdy group of individuals, co-defendants, maybe shaking people down or causing trouble in the parking lot of this bar. Maybe even committing, I thought that there was something about robberies in there.
That's correct.
So committing thefts under force of violence. And then somehow this ends up with an allegation that your client shot a man in the chest. So that's where we're starting from. So when I originally set his bond, and I just want to make a record so everything's clear. When I originally set his bond on this, I set a very high cash bond because that is appropriate on allegations like this. And then the parties came in. All right, so the original bond was $100,000. And then the parties came in. Hold on, let me find it on the ROA. Where's the bond modification? Oh, they posted the $100,000.
Correct, Your Honor. And then
Right,
he was found.
I remember that. I
remember.
remember all that. So the bond was posted, they post the $100,000 or cash or surety form of bond. But I know that there was a motion at some point for the remaining defendants to have a bond reduction. Is that correct? Do you recall that?
I don't recall that. He had a violation of probation for the guns, and then you did not forfeit that.
Correct. Okay, so I'm getting
there.
there.
Increased it to, I believe, 500,000.
Got it. So they post the $100,000 cash or surety. At one of the hearings in this court, I can't recall if it was just a probable cause conference, if it was a bond violation hearing, Madam Prosecutor brings up accounts that are associated with your client, at least to the standard needed for a bond violation hearing. One of the photos shows someone from the neck down wearing the exact same outfit your client wore to court that very day with some very distinct tennis shoes, saying, you know, on my way to court, clock's ticking, something along a countdown. So, I mean, there was pretty clear evidence, in my opinion, to a preponderance of the evidence standard that your client was the one in control of this count, because there were selfies of his exact outfit that he wore on that day to court. There were also photos that were posted that were only considered to make a determination as to whether or not that account was your client's account. And there were photos of his neck tattoo. I believe it's a spider. I'm going off a recollection, or a cross, or it was something large on his neck. So it was clear that the account, both before the really relevant photos and after the really relevant photos, that this was an account run by your client. Then in the middle of all of it, I have got someone who is again alleged to have shot a man in the chest. And there are photos of him sitting on a deck with a leg, which his prior attorney said wasn't his leg. But I am not the stupidest person in Wayne County. And the picture shows a tether on his leg and a handgun, a gun in his hand. It's a picture of his tether and his foot and his gun, or a gun in his possession, that he's posting pictures of on social media. So one of the bond conditions is I've got a guy charged with assault with intent to murder for shooting someone in the chest, and he's posting pictures of a firearm and his tether, making a mockery of not only this court's order, but the law. And for somebody like that, Mr. Wallace, absent an absolute miracle, and I'm making this record clear so you can send it wherever you need to send it, absent an absolute miracle, there is not a chance that I am changing Mr. Santana's bond. Mr. Santana flouted my court order, and he didn't just do it, you know, if he would have been out past his curfew, or even if he would have tested positive for marijuana, those are violations that I could expect from someone of his age that I think are, you know, fairly standard violations. But for somebody on bond for a weapons offense that is a life offense, to post pictures on, and there were others, but that one in particular, for him to post pictures of himself holding a firearm and having the audacity to put his tether in the picture that I ordered as one of his bond conditions, is absolutely outrageous. And I can't think of a judge in this great state that would disagree with me on that. And Mr. Santana, I understand your age. You made a decision. When I'm considering bonds or bond modifications, I have two duties. The first is to make sure you show up to court. And I have no indication or reason to believe that you wouldn't show to court. The second is to protect the community. And the idea that I would let someone out, I don't care who your lawyer is. Mr. Wallace is a very talented attorney, but the idea that I would let someone out or consider a bond modification when you had the most egregious violation other than killing somebody or shooting another gun at somebody, I can't think of a more egregious violation, a flaunting of my order, and your complete disrespect for the court, disrespect for public safety. And there's just absolutely no way that I would modify this bond under these circumstances. There is nothing special about Mr. Santana. Mr. Santana made a choice, and that choice had heavy consequences. and I left him in the care of his mother. And quite frankly, Mr. Wallace, instead of forfeiting that money that could have affected their housing, I have no idea where the money came from. I did not forfeit that bond because I thought that was the decent thing to do, because his parents ultimately shouldn't lose their home because their son makes bad choices. But I've made my record. I respect your argument. I understand you're doing a job, Mr. Wallace, but there is absolutely no way I'm modifying Mr. Santana's bond.
Okay, thank you, Your Honor.
All right, we're all set. Thank you.
That's all, folks.